Hey, folks, welcome to this week's Trump's Trials and Tribulations. It is a fateful one. This is the last time I will be coming to you from the Mar-a-Lago bathroom studio because this is the last Trump Trials and Tribulations. It's not the last Lawfare Live we're ever going to do. By no means. We will continue to do Lawfare Lives on a regular basis. It is not the last time we will do Lawfare Lives on legal issues involving Donald Trump. God knows he will generate enough of those as president, but it is the last one of the series Trump Trials and Tribulations. And why is that? Because there are no more Trump Trials and Tribulations. If you were going to have a series called Trump Trials and Tribulations, you have to have a Trump who is on trial and tribulating, which he is not anymore. From the Mar-a-Lago bathroom studio, I'm Ben Wittes, editor-in-chief of Lawfare, here with, in the Scott studio, Roger Parloff. Are you going to abandon the Scott studio now that we're done with Trump Trials and Tribulations?
No, I'll be here for our other Trump live thing, not lawfare live things.
Okay, the Scott studio will remain. Quinta, I suspect the Endless Scream Pillow studio is going nowhere. Is that right?
No, that endless screaming is only more apropos. I
All
may
right.
cover the entire room with endless scream wallpaper.
And Tyler McBrien, you are joining us from not from the from the Martha Stewart kitchen studio, but like from just next to it. Is that right?
It's actually the other end of the Martha Stewart kitchen, which is also my living room, which is also my bedroom. So I'm in a studio in many senses of the word.
Yeah, there we go. And Natalie Orpett, what we don't have a name for your studio. Is it just the Natalie Orpett office studio?
The boring institutional office
The
studio.
boring institutional office studio, and Anna Bauer, who is joining us from the which room of your palatial mansion is that? I don't think we've seen that one before.
Sorry, I have something in my eye. But this is the uh burn your presidential records in the fireplace studio.
The burn your presidential records in the fireplace room of the palatial mansion, which transcends time and space. All right, let's start. We're going to spend a lot of time today on sort of high altitude thoughts on what was and wasn't accomplished with all this trialing and tribulating. But let's start with the wind down. Quinta, get us started. The case in DC, it's just gone, right?
It is gone, although with the possibility that it could be raised from the dead after Trump departs from office again in 2029. So shortly after the election on November 8th, Jack Smith filed an unopposed motion to vacate the briefing schedule, which I don't think was a huge surprise, but he then left us in suspense until November 25th, when he filed a motion to dismiss, which was unopposed and which was granted by Judge Tanya Chutkan. I think there are a few things that are worth noting about this motion to dismiss, although, as you say, the bottom line is this case is gone. um, Smith essentially said, look, we talked to the Office of Legal Counsel, and we have determined that given the existing OLC memos that establish that in the view of the Department of Justice, and of course, given the Supreme Court's opinion in the immunity case, adopted by the judiciary as well, the president cannot be prosecuted during his time in office. This obviously leaves open the question of, okay, well, what about prosecuting a president in the window between his election and his inauguration. And according to Smith, OLC indicated that the transition period is also ruled out for moving forward with the prosecution. And so on this basis, Smith asked for the case to be dismissed, which Judge Hunkin did. It's notable, however, that the case was dismissed on Smith's request without prejudice, which means that it could technically be refiled. If it had been dismissed with prejudice, there would be no possibility of reviving it. It would be 100% dead. They specifically requested it to be dismissed without prejudice. I think there had been some speculation, which I had certainly engaged in, that one of the advantages of moving to drop the case in advance of Trump coming into office rather than sort of sticking around and waiting for Trump to order it dismissed would be the possibility of getting that dismissal without prejudice. The question then is how you would actually move forward with it at the end of a second Trump term, given the statute of limitations, which I believe is 5 years for all of the charges in the DC case. I know that may not be the case in Florida, and Roger, I'll leave it to you to speak to that. But in DC, at least, the statute of limitations should be 5 years from 2021, in which case it will be extremely expired by 2029. So that leaves the question of what the point is of seeking a dismissal without prejudice in the first place. And Smith kind of hints at this in his motion to dismiss the case by pointing to this idea of equitable tolling. He notes the OLC memo that was released in 2000s following the Clinton impeachment about indicting a sitting president, where OLC had, and I'll just quote from Smith's summary here, OLC recognized that the interest in avoiding a statute of limitations bar by securing an indictment during the presidency is a legitimate one, and noted the possibility that a court might equitably toll the statute of limitations to permit proceeding against the president once out of office. So equitable tolling would essentially mean finding that the statute of for sort of finding an exception to the statute of limitations, essentially. I believe that would have to come, in 2029, that you would ask a court to find that this had been the case and that you could move forward despite the expiration of the statute of limitations. I suspect that would probably be a pretty heavy lift. It's not like there's a huge amount of precedent for that specific move. But I do think that it is notable that Smith kind of put that on the table and hinted at it as a potential future move.
All right, so that's case number one. Case number two, let's stick with the feds for now. Roger, Florida is a little bit more complicated, but not a whole lot more complicated. What's going on there?
Yeah, in Florida, you remember that so the case had already been dismissed by Judge Cannon based on procedural grounds, the theory that the special counsel was improperly appointed. And so that was on appeal to the 11th Circuit. And so the day after Jack Smith moved to dismiss the DC case, he moved the 11th Circuit to dismiss Trump from that appeal, but only Trump. So Walt Nauta and Carlos de Oliveira, the case continues as to them at the moment. And they also filed Jack Smith filed his reply brief in that case. So that was November 26th. So that briefing is complete. So in theory, no argument has been set yet. So in theory, the appeal could go forward and we might find out what the 11th Circuit thinks about how you can appoint special counsels. The problem or the issue is what after January 20th, what will the Trump Justice Department do with this case? the special counsel will presumably no longer be involved. By the way, we didn't mention that neither of these motions mention it, but presumptively, Jack Smith will write a report in each case. The way the statute is written, it's sort of mandatory, and it says that you will write a report, a confidential report that you give to the Attorney General, and then the Attorney General can decide whether to make it public. And Merrick Garland has made all of the previous reports public. So that will presumably happen. But anyway, the question here is, once he withdraws and once Trump takes over, will he pardon Nauta and de Oliveira, or will he have his acting attorney general move to dismiss their cases? And presumably, I mean, I think there's a high probability of that. So we might never get to the merits of this case, however interesting they might be.
Can I ask a stupid question about how this is gonna, what the wind down here is gonna be? Because one problem with having your deputy attorney general be somebody who worked on the case is that it becomes hard to ask him. First of all, I assume he would have to recuse himself, although Pam Bondi, don't know that she's involved, wouldn't. It seems to me that if you want to get this done quickly, and you may have a little bit of time where there's going to be an acting attorney general who's got to be someone from within the department, you kind of got to do it with a pardon, right?
Well, I don't really see why. I mean, you can have an acting deputy attorney general. I don't see why there is and I don't think you need a principal officer or an inferior officer or anybody to
No, but you do need somebody who's not recused and who's presumably not career, because somebody whose career is gonna look really askance at an order from a president to drop a case. I mean, you're gonna get into some weird territory. It just seems like the cleaner way to do it is just.
I don't think Judge Cannon's going to give this a very severe look, and I don't know. I assume that it would be her and not the 11th Circuit. Maybe I'm wrong about that, and I just assume that, for instance, well, I don't know the. It is possible that there would be a delay, but I also think they have a little bit of time. There's no argument set yet, so they don't have to do this immediately. I sort of.
Sorry, go ahead.
I mean, I sort of think that the preference on, knowing Trump the way I do, I don't know him personally, but obviously, but it would seem like he would prefer to dismiss it, because you can have somebody say, this should never have been brought. This was a politically inspired vendetta, blah, blah, blah. We move to dismiss. Judge Cannon says, you know what? I agree. And there it's on the record. So I sort of assume it will go something like that.
Gotcha. All right. Let's turn then to the second most complicated case, which is Georgia. Anna, we got several threads going in Georgia at the same time. How is the wind down going, and what's it going to look like?
Well, I don't know that there is a wind down for some of the defendants, but certainly there is a attempt at a wind down that's going on behalf of Trump's counsel, Steve Sadow. Keep in mind that the current posture of this case is that everything at the trial court level for Trump and a number of other defendants is frozen. The Court of Appeals is still considering Trump's appeal of the disqualification issue regarding whether Fani Willis should be disqualified from prosecuting Trump and others in Fulton County. And we had this kind of weird thing that happened recently a few weeks ago. We didn't do a Trump trials that the week that this happened, but the Court of Appeals had oral argument scheduled before the election on this issue of the disqualification appeal. They then refused to change the oral argument date after Steve Sadow, Trump's counsel, requested it because he had a long planned trip that he was going to do with his wife. And, he made this plea to the Court of Appeals to please change this date. And they said, no, we want to keep it on December 5th. And so it seemed like things were going to move forward with this appeal with the argument. And then the election happened, Trump won, and the Court of Appeals, quite surprisingly, canceled oral argument. And, again, quite strange considering that it had resisted Steve Sadow's efforts to kind of put it off. And it also
Maybe they didn't want to have an argument, but they also didn't want him to have a vacation with his wife.
Perhaps. They also granted extended time to all the defendants only a few weeks before this happened, where they canceled it. So it was a little bit unusual. People didn't know what to make of it. There are a few theories being thrown around. One, I think that people who are kind of more on the side of the defendants have been putting out there is that maybe the Court of Appeals is just going to send it back down to the trial court to sever Trump. Perhaps the Court of Appeals, the other theory is, just knows that it wants to disqualify Fani Willis. But then the other side of things, and one that I find, I think, somewhat compelling, but we're really all kind of in the dark here, is the idea that it relates to this motion to dismiss as improvidently granted that Fani Willis filed over the summer, in which she basically said the factual conclusions that the trial court arrived at, no matter what the Court of Appeals were to do, the factual determinations made by Judge McAfee basically can't be reversed here. And so therefore, the only outcome here is that there is no conflict of interest that would be disqualifying. So the idea that some people have...
Because he found that as a matter of fact.
He found as a matter of fact that there was no showing of, a financial benefit that was gained, that there was no conflict of interest. And that is a factual determination by the trial court, that the Court of Appeals could only come to a different decision at if there's, clear error. It's basically, she was saying, like, these factual determinations are such a high bar that the Court of Appeals never should have even granted this appeal, because there's not a whole lot of wiggle room for the appeals court to make a different determination than the trial court. So the idea is that perhaps the Court of Appeals realized it wants to grant that motion and go ahead and dismiss without hearing oral argument and send it back down to the trial court. But we haven't heard from the Court of Appeals, so we have no idea, and we're all still in the dark. And while this is happening, shortly after the Court of Appeals cancels its oral arguments, Steve Sadow submits a notice of jurisdictional issue, is I believe how it was titled, in which he tells the Court of Appeals.
Oops, we have lost Anna momentarily. Thank you, Elon Musk. All right, we will come back to Anna when she comes back to us. Whoops, we lost you for a minute,
oh dear,
Anna.
I'm so sorry.
We
Am I
blamed
back?
Elon, and now you're back.
Where was I?
You had just explained that we hadn't heard from the Court of Appeals, which throws a wrench into this theory.
Yeah, so we haven't heard from the Court of Appeals, and while we're, all waiting on this Court of Appeals decision to tell us what it is that they're thinking or doing, Steve Sadell submits this notice of jurisdictional issue, is I believe how the motion was titled, and he basically tells the Court of Appeals one of the defendants who's a part of this appeal was just elected as the next president of the United States, and as a result, you have to consider a potential jurisdictional issue here in that you are soon about to have no jurisdiction to entertain any kind of case against him. He cites the OLC memo in which the OLC came to the conclusion that a sitting president cannot be prosecuted while in office, cites the supremacy clause, and then says, as a result of this jurisdictional issue that you're about to encounter post January 20th, you should dismiss the appeal, send it back down to the trial court, and tell the trial court to dismiss the case altogether against Trump. And then of course, it's kind of unclear then how exactly, it was presumably the appeal would still continue against the other co-defendants because this motion only applies to Trump. But essentially that's kind of where we're at, where we have this motion that is a notice of this jurisdictional issue. I think that what could happen here is that maybe the Court of Appeals just looks at this motion and decides anyway, but it also could order briefing and get the state's opinion on the matter and that kind of thing, and that could prolong things even more. So we'll see, but that's where we're at in Georgia.
One other Georgia thing, though, the estimable Ken Chesborough has decided this is a good moment to reopen his guilty plea. Any sense of what's going on there?
Yeah, so a few months ago, Judge McAfee dismissed some counts against various co-defendants, including Trump in Fulton County. One of those counts was count 15. It was a conspiracy to file false documents charge. And that charge related to the fake electoral certificates that were submitted to the chief judge of the Northern District of Georgia, that's federal court in Georgia. And Judge McAfee dismissed it on this preemption claim, looking at this very old Supreme Court case in which basically the idea is that a state prosecutor can't prosecute someone for perjury or false filings in a federal jurisdiction. So here that being, federal court, the Northern District of Georgia. Well, turns out that is the very count that Ken Chesborough pleaded guilty to when he pleaded guilty last fall. So keep in mind, he was charged initially with 7 felony counts. A part of his plea deal included just pleading out to this one felony count that was the conspiracy to file false documents. So he took that very generous plea deal. But now that Judge McAfee has made this decision throwing out count 15, he's come back and said, actually, I think that you should invalidate this plea because you threw out those counts.
But if he invalidates the plea, then the other charges, minus this one, which he's thrown out, potentially come back, right?
Yeah, presumably. And I'm still trying to get a sense of what all of the various consequences here would be, but the presumably it would be the case that Fani Willis could still bring those charges back against Ken Chesborough. And maybe he's just rolling the dice here that she would no longer have as much incentive
I think
to.
he's rolling the dice that she's going to get disqualified. The case is going to collapse entirely, and he was a fool to take the very generous plea. So if you get rid of the plea, yeah, theoretically you get 5 or 6 extra charges, but in fact, what's going to happen is the case is going to fall apart, and you end up lucking out like young Slime Life people.
Yeah, and keep in mind that currently he's suspended from practicing law in New York as a result of his plea in Georgia. So, there may be that. He's also has pending charges in Quinta as our state court expert. Correct me if I'm wrong, but Arizona, and he's cooperated in some of the other states, though, correct?
I excuse me. I confess I've lost track of precisely which states. I know there are pending charges against him in Michigan, I believe, not in Arizona.
Oh, excuse me, Michigan.
But
then.
he definitely cooperated in Wisconsin, right?
Yes, and so he's got a lot.
No,
of.
sorry, it's the other way around. There are charges against him in Wisconsin. I don't think there are charges in Michigan. I don't think there are in Arizona. It's incredibly difficult to keep this straight. I will confirm this while we're talking.
All right.
Okay, so the point is, though, he has a number of legal issues in other jurisdictions, and there are a multitude of ways that potentially having even though he in Georgia, he was under the First Offenders Act at the time, I believe he only had the Georgia charges pending against him. So there's a number of different things that could have gone into the reason why maybe Ken Chesebro wants to roll the dice here. I will say that from talking to people who practice in Fulton County, it seems like he does have some issues.
Whoops, we're losing Anna again. All right, let's go on to New
Well,
York.
while we're waiting for Anna to come back, I'll say, so he is a unindicted co-conspirator in Michigan and Arizona, and has been charged in Wisconsin.
Gotcha. All right, Anna, are you back?
Yeah, I'm back. I'm so sorry. Everyone should absolutely blame Elon and not Lawfare for this.
This is what happens
you know?
when you rely on Elon Musk to join Lawfare from rural Georgia. Anna, so you were finishing up about Ken.
Yeah, so this motion does, from talking to defense attorneys and who practice in Fulton County, it seems like this motion does maybe have some issues. Most of the people I've talked to suspect that Judge McAfee will deny the motion, actually. One reason being that we've talked before on the podcast about how in Georgia, they're really specific about the type of motion that you're bringing at the trial court level when you're practicing, when you're doing criminal defense practice. There's plea and bar, there's special demurrer, there's general demurrer, there's various different ways that you can bring a motion, but there are different restrictions on what type of motion you have to bring and how when you can bring it and all that. And so here the appropriate type of motion to bring is something called a motion in arrest of judgment. Unfortunately for Ken Chesebro, the statute indicates that the motion to withdraw the plea, which is the type of motion that he would need to bring here, would have had to have been brought within the same term of court that the judgment was made. So the same term of court that he made the plea. And most people who I've talked to have pointed this out and note that Ken Chesebro in this motion that is styled as a plea and bar. So they don't really they're trying to get around this, I think, by styling it as a different type of motion. But they do note in a footnote that the statute requires that, a motion in arrest of judgment is an alternative form they could have brought and that it would have been required in the same term of court. So they're acknowledging that in the motion, but trying to, kind of basically style it in a different way, I think, because it might help them with the untimeliness issue. But so that could be an issue. And, I'm curious to see, like, Natalie, I know that you in various contexts may have dealt with withdrawals of pleas. So if you have thoughts, but essentially, I just think that this motion may have some issues, and we'll see what happens.
All right. Let's go to New York. Oh, sorry,
Can I
Natalie.
I just actually want to add one sort of amusing tangent, but that actually does raise something that will be interesting to keep an eye on, perhaps, which is there was a small victory for civil procedure professors everywhere who need to explain to their students why proper service is actually really important. And that is that there was a motion was an open records request to the district attorney's office by Judicial Watch asking for communications between Jack Smith's team and Fani Willis's team. The district attorney's office responded that they didn't have any responsive records. Judicial Watch sued, and there was some confusion with regard to service, but ultimately service was properly effectuated. And the district attorney's office didn't timely respond to Judicial Watch's brief. And so the court issued a default judgment ordering the district attorney's office to produce records. So it's possible that nothing comes of this because in the initial response, the district attorney's office said that there were no responsive records, but it is a headache that the office is now going to have to deal with. And it is possible that, for whatever reason, that was the initial response, but there are responsive records elsewhere that there will now be a more of a burden to find. So we'll see if anything comes of this, whether there is, this was an issue people were quite focused on very, very early in all of these litigations, was the question of the extent to which federal investigators would coordinate or communicate or share evidence with state level prosecutors and investigators. So TBD whether anything comes of that, but in the meantime, hooray for civil procedure.
All right, let's turn to our last case. Roger, what happened in New York? We have a conviction. We have serial pushing the deadlines to figure out what we're going to do about it. I've lost track of things. Where are we?
Yeah, everyone has lost track of this one. We have at least two pending motions at the moment. There was one filed back in July, which is the motion for a new trial based on the allegation that official acts evidence was used at the trial, which later became was allegedly improper under United States versus Trump, which was decided after the trial. So that's pending, probably ready for a decision. But then on December 2nd, Trump filed another motion. It's sort of two motions. One is called a motion to dismiss based on a legal impediment, and the other is called a motion to dismiss in furtherance of justice. The motion to dismiss in furtherance of justice is a pretty common motion in New York, and it's a grab bag of reasons for dropping the case. And that's why it's a 69-page motion, because he's written a grab bag of reasons, most of which are grievances that have been rejected and rejected and rejected and rejected. But there are two new arguments, one of which is quite strong. And it stems from the DC, primarily, I would say, from the motion to dismiss in DC. Or at least the motion to dismiss in DC is what makes it so strong. And before before getting to it, I'll just say at the end of this 69-page motion, they say, by the way, if you reject the first motion, the motion for new trial, and this motion, please advise us and give us 2 weeks because we want to move to get a federal injunction to prevent you from going forward with the sentencing. By no means can you go forward with the sentencing. The strong argument they make comes from this language in the DC case. You know, what Jack Smith, one of the things he asked OLC was, what if we freeze this and then continue it after Trump's term in 2029? And OLC decided, no, you can't do that. And there were 2 prior, OLC rulings, one in 1973, one in 2000. And what Jack writes is, Jack Smith, OLC concluded that its 2000 opinions categorical prohibition on the federal indictment of a sitting president, even if the case were held in abeyance, applies to this situation where a federal indictment was returned before the defendant takes office. And then it
Roger,
goes on.
why does that imply that you can't go to sentencing? It might imply that you can go to sentencing. It just has to be done by January 20th.
Well, that's because I think and let me just get the last sentence of that, which is, the Constitution requires that this case be dismissed before the defendant is inaugurated. The reason I don't think you can get to sentencing is because you have these 2 motions, and there's a good case to be made that both of them are subject to interlocutory appeal. The first one is that one that stems from United States versus Trump. That's the motion for a new trial. And of course, the Supreme Court majority said that these immunity questions are subject to interlocutory appeal. It's not, free from doubt, but it might be that even here, you would need to appeal that before you could proceed to sentencing. That's a fairly good argument. And then I think in addition, there's this new argument that's pretty powerful too, that OLC is saying the Constitution requires that this case be dismissed before the defendant is inaugurated. And if he's not going to dismiss it, that too might be appealable. I'm not sure when he says that he would seek a federal injunction, exactly who that would come because there's a further wrinkle, which is that he has already tried to remove this for a second time to federal court. It was denied for a second time, and that's on appeal to the Second Circuit. And he's filed a brief to the Second Circuit, and district attorney's response to that is due January 13th. So there's no way in the world that case can be decided in time. And he also makes a claim that we need to find out what happens there before we can move to sentencing. I think that's a weak argument. Anyway, there's a lot of obstacles here, but I think the biggest one is that the language of Jack Smith's letter or motion is very strong. Now he has a footnote and he says, we're not taking any position on state cases, but it's very hard to understand how the Constitution could require that the federal cases be dismissed and not require the same of state cases.
It's true, although the fact that the Justice Department takes that position doesn't mean it's right. And although I have no doubt that the federal courts would agree with the Justice Department, given their sense that you can't even prosecute him later, All right, let's before we go on to the high altitude thoughts, Tyler, you have an addendum on this case. You were
Let's go to the low altitude thoughts.
yeah, let's
The lowest.
I hear that there was kind of like a reunion of Trump trials journalists that convened the other day when we thought there was going to be a ruling on December 2nd. What's the skinny? What's the gossip?
So now turning to Lawfare's media correspondent, I guess. You're right. So last week, actually, let me back up. So the day that we got the verdict, I wonder if Anna can attest to this. When the press corps at least left the courtroom, there wasn't this sense that, goodbye, farewell, goodbye forever, because we all knew, or we thought we knew, we'd be back soon for a sentencing hearing, and it would be the same sort of group. So it was almost like getting out for summer, for a school break, the end of a semester, and you'll come back. Of course, everything that Roger just said and everything that we know, it's December 5th and there has been no sentencing hearing. So on November 26th, there was a very informal, low altitude, as you said, happy hour reunion of sorts for open to the New York reporters who were at covering the criminal trial. Let me get the exact name, which was the Trump trial non-sentencing, non-happy hour. November 26th being, of course, one of the scheduled dates of the sentencing hearing that never was or never will be, or who knows. I gotta say, it was there was some laughter, there was some tears. I didn't actually see any tears, but it was nice to see familiar faces, to commiserate on the madness, the whirlwind of the trial, and just kind of take a step back and talk about it. But I thought it would be amusing color for anyone who wasn't aware of the happy hour.
Excellent. All right, let's step back and reflect a moment on this process of trialing and tribulating. In order that you all appear on my screen, which is to say Roger, then Natalie, then Quinta, then Tyler, then Anna, and I will go last. We've had a 4-year process of accountability. Some of it has involved Trump himself, some of it has involved other people, presumably some of whom, or maybe all of whom, are now going to get pardoned. We're not sure. It's involved Congress, it's involved the executive branch, it's involved the courts. What's worked here and what hasn't? Roger, your thoughts.
Well, this was not a great success. I don't think you can ignore either of the federal cases and not bring them. I think that would be a terrible mistake. You have to try to do justice. And there was powerful evidence, and serious crimes. He was very successful in, there was the big lie which led to the January 6th events, the election lies. There has been a big lie since then that these two cases were politically motivated. And that was very successfully aired by his lawyers who were zealously representing his perspective. And that's created a very harmful experience where an entire political party is pretending to believe that. And so we are getting a situation where it was part of the platform of this the one who won, be vindictive, to bring vindictive prosecutions to as retribution for this his prosecutions, which we have to pretend were not valid. Part of the way he justifies that, or the way his people justify that, is by focusing on the New York case, which is sort of the weakest link. You can make the more colorable arguments that that case has political elements. You know, a lot of cases brought by elected DAs have a political element. You know, if you decide whether to bring the capital punishment or not, you sort of look around your district and say, how is this going to go over at the next election? That happens. And presumably these positions are elected because at some level people want these to be politically based decisions. They want accountability. Anyway, the New York is the weak link, and they've and unfortunately they've made hay with all of these cases and portrayed them all as politically motivated, and it's been a catastrophe. But I don't know what to do with that. You can't not bring these valid cases, and I guess we get to the should they have been brought earlier. But that's I guess that's where I'll start.
Natalie?
Yeah, so I think I'll go a little bit more conceptual if that's okay. There are a bunch of different ways to think about accountability, and this series has focused mostly on the trials aspect of Trump trials and tribulations, but has also focused on other efforts at accountability, I guess, in the tribulations category. Most of what I've focused on over these years has been in relation to January 6th. But it's not the only means by which accountability has been sought. But in the January 6th context, there was the initial attempts at accountability for Trump, and those were, trying to figure out if there was a mechanism under the 25th Amendment for disqualifying him from office. There was the impeachment. There were a bunch of investigations. There was the January 6th committee that told this story and tried to hold him politically accountable and investigated and brought out the facts. I think there are, to varying degrees, ways that you can think about whether those forms of accountability were effective. And again, that's limited to sort of the January 6th context, but perhaps worth thinking about. Another type of accountability was the sort of holding accountable other people who were part of this effort, which includes both the sort of inner circle people, actual co-conspirators, named or unnamed, indicted or unindicted, as well as the sort of more distant group. And this is to borrow Roger's framing, which we used quite a bit in The Aftermath, which is our narrative podcast series on the response to January 6th. There was tremendous success in holding criminally accountable what Roger referred to as the blue collar offenders, which were the people who committed the actual crimes at the Capitol, the sort of kinetic crimes. And there was much less success holding criminally accountable the white collar criminal defendants who were indicted for other reasons. But there were several white collar types of criminal convictions of others who sort of aided Trump's efforts in connection with January 6th. Some of them criminal, some of them other. We've talked about this at length, but I won't go too much further on that. I think all of that context, and then turning to the question of these criminal trials in particular, there's a way in which you can see the Supreme Court's immunity decision as effectively saying that the law itself operates in parallel with the office of the presidency. And there are times at which the two will meet, but they are limited by the separation of powers because Congress can't impose on the office of the presidency normal criminal statutes in a way as neatly as it does on the rest of the population. And so there is a question, I think, fundamentally, conceptually, of whether the law, the criminal law in particular, is the mechanism through which Trump even could be held accountable, at least with respect to January 6th. There's the last thing I'll note is just to reference a debate that Quinta and I on the one hand and Ben on the opposite end had in the summer of 2022 before Trump was indicted for January 6th. And that was a question of whether DOJ was meeting the moment in Quinta's and my formulation, which was the question of whether the investigation was proceeding on the timeline that it should, which we didn't actually opine on, but rather focused on whether DOJ was playing the appropriate role in sort of asserting the rule of law and the importance of it in the aftermath of what was an attempted insurrection. I'm not sure where Ben stands on that. I'm not going to relitigate the timing of when this was brought, but I think all of this, to wrap up, raises some very difficult questions about what the law is capable of accomplishing with respect to accountability.
Quinta.
I think I'm largely on the same page as Natalie on that score, but let me tweak it a little bit from my perspective. I think that in the early Trump years, so sort of initially after the Russia investigation was launched and then after the appointment of Robert Mueller, there was a lot of rhetoric around this idea that Mueller was kind of this, white knight who would come in and save the country from Trump. There were Mueller votive candles, there were t-shirts. I have an action figure above my desk. And I think that after the immunity opinion and after the DC case was dismissed, I saw a lot of rhetoric, including in particular an op-ed written by Samuel Moyn in the New York Times that was kind of hearkening back to that language around Mueller and saying, see, it was always a mistake to think that, the law could save us. I think that, those votive candles were very popular in 2017 and 2018 and 2019. It's 2024, and I think that the way that the sort of commentariat is thinking or should be thinking about the role of what the legal system can do here has matured a lot from those early days. I don't think there was any, certainly just speaking for myself, illusion that the legal process was any kind of a substitute for the political process here, or that it would, provide a solution if, a majority of Americans decided that they wanted to vote for Donald Trump for president anyway. That said, I also think that it's a mistake to look at the results and say that the conclusion that we should draw here is that, that this was all a waste of time, that there is very little that law can do, which is not to respond to anything that anyone's saying here, but more to the sort of ambient sense of doom. I think that my takeaway has actually been, to some extent, the opposite, that, I think there is a very good argument that DOJ should have been more aggressive here. What we know now about the process of the January 6th investigation, certainly, I think that there's certainly an idea that, Merrick Garland made a terrible mistake in not indicting Trump on his first day in office. I'm being a bit flippant, but not that I'm not going that far beyond what some people have argued. These investigations do take time. These were difficult decisions. That said, I think there is good reason to think that DOJ really was not moving as quickly and as aggressively as it should have immediately after January 6th in focusing on Trump specifically and pursuing charges against him. I also think, by the way, this is not just a problem with Maine justice. The New York case against Trump, you know, for all of the argument that it was politicized because it was brought by this elected DA, which Roger had pointed to, that case was brought by the DA in part because the U.S. Attorney's Office for the Southern District of New York, which had been investigating, decided not to pursue it. We don't know why they didn't decide to pursue it, but I wrote about this in Lawfare during the trial. I think there was very good reason to think that it may well have been that SDNY essentially decided this case is old news, it's small potatoes, we don't need to pursue it. January 6th is a sort of a bigger deal, leave Maine justice to that. And that you can imagine a different world where DOJ, in all of its manifestations, moved much more aggressively to pursue legal accountability for Trump for these cases, and that I don't know if that would have made the election outcome different. But I do think that the process would have been potentially substantially farther along, and we would have been closer to real criminal accountability, or at least a jury verdict in more of these cases for what happened.
Tyler, your window on this is a little narrower than some of the others, but you did sit through the New York case. What's your big picture takeaway from all of it, other than happy hour?
Yeah, no, I as you mentioned, I'll probably cabinet to the New York trial. I think one thing that worked really well for us is the word lawfare is back in vogue, and we've gotten some great Google search windfall, I'm sure, from that. I'm only half kidding, I think, there. But in all seriousness, I think just thinking about the happy hour, I didn't hear from anyone that this wasn't worth it, or this was some big mistake. Again, these are mostly reporters. And in thinking about the American public grappling with the limits of law and in achieving accountability or justice, I think people going into the trial or at the beginning of the trial were already grappling with the limits of the law. I mean, I don't think anyone, no matter how strongly you believed Trump was guilty of what he was accused of at the very beginning of the trial, I think very few people actually thought he would go to jail, for example. Jail is only one form of punishment, one form of accountability of many. I think some things that worked well that came out of the New York trial, and similarly with court filings of the other cases, were the findings of fact and the presentation of evidence, and putting things on the record into the public domain, describing certain behaviors by Trump and his associates that were very unsavory and I think wouldn't have come to light otherwise. I think, Roger, you mentioned once on a live stream, I think it may have been during one of the David Pecker days or another one, where it's just you're at this trial and you're just steeped in this behavior and you just feel gross. I mean, it's just like witness after witness, document after document. And I think it's important that the public was able to learn about it, that it will be there for posterity. Again, whether the people ignored it, whether they didn't believe it, whether they saw it and were okay with it, is another matter. Trump obviously won the election, but I think it's worth doing just to get it out there.
Anna.
Yeah, look, I don't want to repeat what others have said, but I will just kind of continue where Tyler left off, which is that to me, I think that truth telling is an essential aspect of accountability. It may be that Trump is never held accountable in our lifetimes, but I think that, even looking beyond the legal system and these trials, looking at the work of for example, journalists who, in many cases, were the people who uncovered much of what went on. What we learned in the Jack Smith immunity filing is not all that different from, what we already knew from public reporting, and then also from the January 6th committee, of course. That was also another critical element of this kind of truth-telling element to accountability. And again, it's to me, what matters is that there were people like us, other journalists who cared about bearing witness to these trials, who went and told people about it and wrote about it and told the truth. And again, it may not be that in our lifetimes there's any accountability for any of it, but history will be the judge. And so I think that that's lately what has is something that I have found to be important to consider when thinking about accountability and the kinds of things that we're talking about here.
All right. I am going to offer the following thought, and then we will go to audience questions, which is picking up on Quinta's point about the legal system being no substitute for the political system. And I want to say that the fundamental failure here is a failure of the political system, for which we cannot ask the legal system to step in and fix. And that failure took place when the Senate had the opportunity to disqualify Donald Trump, and it didn't bother. And the reason this is so significant is that at that point, stopping Donald Trump from taking power again became a political question. That if he could persuade enough voters, which he could, the legal system wasn't going to stand in the way. And by the way, shouldn't stand in the way, right? I mean, in a democratic republic, the desire of a majority in the electoral context is in fact the highest calling. And the political system actually had a remedy, which was the impeachment and disqualification process. And a group of senators decided not to exercise that. And they specifically said, let's leave this to the criminal justice system. And thereby asked the criminal justice system to do a democracy protection function, which is really the function of the Senate in the impeachment process and the voters. And the senators decided not to do it, or at least 10 of them did, and including the minority leader, Mitch McConnell. And the voters were ultimately persuaded for the myriad reasons that voters are ultimately persuaded by things. And I think my big takeaway from this is don't ask the criminal justice system to step in and fix problems that the political system actually has perfectly good remedies for. We should demand those things of our political leaders, and we did not successfully do that, or the leaders failed. We didn't hold them accountable for that failure. And that strikes me as the most important, most fateful moment here. All right. We have a barrage of questions. I'm going to get through as many of them as I can, but we're going to end promptly at 5:30. Josh asks, what do people think about Paul Rosenzweig pardon proposal? Would some blanket pardon for any prosecution of Trump's enemies as listed by DJT himself or Kash Patel? So this appeared in The Atlantic. Paul is, of course, a frequent Lawfare contributor. He's on our masthead. Look, my view of this is a potentially legitimate use of the pardon power. I wrote this, yes, with specific reference to this column, wrote this the other day with reference to Biden's pardon of his son. It is not an obvious use, and to me, the question of whether it's merited partly depends on the desires of the people in question. I feel very differently about it if Liz Cheney wants protection than if she feels, you know, pardon me, fuck that. I didn't do anything wrong. I don't want to, you know, exist under the shield of some act of presidential power that might be construed as implying that I did something wrong. I feel like the appropriate thing to do for Trump is for Biden may be to consult or have his White House counsel's office consult the affected community. I agree the relevant group of people is the people Trump has specifically named, or in some cases, Kash Patel has named. And I think it's a little bit different if for those people who say, yeah, I don't want to be investigated and drive myself to financial ruin, than for those who say, um, uh, you know, I'm a very proud person. I didn't do anything wrong. Bring it on. And by the way, suspect there are people in both communities.
Can
Yeah,
can
go
I weigh
ahead.
in here? I've actually been wondering about whether it would be possible to draft sort of an even bigger blanket pardon along the lines of the Jimmy Carter pardon to Vietnam era draft dodgers, that would scope more broadly, because one of the sort of uh, geniuses of Trump is in identifying as people essentially at random to persecute because they happen to say something intemperate or in many cases did nothing at all. So I have even less idea how you would put that together. But I do think it's a potentially interesting idea. I mean, the draft dodger pardon essentially says specifically anybody who committed this specific offense between these dates, and then you can apply to receive it. Obviously, draft dodging is a very specific statutory offense, unlike this, which would require, much broader language. But I do wonder what that might potentially look like.
Yeah, I will just say that the broader a pardon gets, the more vulnerable it gets in any application to suggestions that it's insufficiently particularized to apply to the offense and the individual. And obviously, when you're talking about a large group of people who might need some protection, each of them is better off if you name them. On the other hand, for those who are proud and don't want to accept a pardon, doing it in some group may actually be a very good way of avoiding that problem. Josh also asks, any thoughts/news about the civil judgments against Trump, Jean Carroll, Tish James, etc.? Has anybody been following these closely over the last few weeks?
I'm keeping track of them. The Engeron judgment seemed to be in trouble in the First Department argument. Didn't seem like it would survive in its current form. It will either be cut down quite a bit or might be reversed. A lot of very split panel, so hard to tell. The E. Jean Carroll cases, one case, the what's called Carroll 2, has been argued at the Second Circuit. That's the $5 million verdict. She drew I would say, a favorable panel to all Democrats and 2 women. But there were some questions of first impression, so it's not completely clear. And then the second one is still being briefed. That's Carroll one, which is the
which
83
is the
point.
second.
Yeah, the one that went to trial second it was filed first, but went to trial second. That's the $83.3 million one. That one, Trump's filed his appeal brief, and she has asked for more time and will file probably in January 27th.
All right. Nathan asks, we're going to have to narrow this question, like the first divisions are going to have to narrow the Engoron verdict. What's everyone's reckless speculation on the federal rule of law going forward from this moment in time, given Trumpism in all its varieties and the Supreme Court's shifts to the further right over the past few years? Do you see our constitutional system robust enough off in the future, or will this era look like a merry, weird hiccup or worse? Natalie, this is on you. What do you think?
All the law schools are going to shutter. No one believes in law anymore. It's all down the drain. Yeah, I don't know how to answer this question.
Anyone
I
have
think
thoughts on
that
it?
I will just say that the one thing is that much like we learned in our civics lesson that was learning about presidential elections in the aftermath of January 6th, and no one knew what January 6th was all about or how elections were certified until all of this happened. Much in the same way, I think we are now more familiar with the patchwork and diffusion of courts and state authorities and federal authorities, and there are an awful lot of actors in the legal system, and even those with extreme amounts of power can't immediately reverse all of the many good actors that there are functioning in that diffuse system.
All right. Frederick asks, why doesn't Jack Smith indict Trump's January 6th co-conspirators? The indictments would be withdrawn on January 20th, but the evidence would be put on the record: Giuliani, Meadows, Eastman, Powell, etc. So there's a very simple answer to this question, which is that the Justice Manual says that you cannot bring an indictment as a federal prosecutor unless you believe that you have a reasonable probability of obtaining a conviction. And that means you're not really supposed to do it for purposes of putting evidence on the record or making a statement before a new president comes in. And so I think the chances that the Justice Department would consider that consistent with department policy is near zero. That's what I think the answer is. Does anybody have an alternative reason or think otherwise?
I mean, it's worth noting that I think the bulk of the evidence against those individuals has already been made public as a result of Smith's filing on presidential immunity that was made in October, and the related appendices. There's an extraordinary amount of material there. I mean, that doesn't mean that there couldn't be more, but there's a lot. And it's also true that, if there is a Smith report released by the Attorney General, that would allow the release of a huge amount of information without that attendant concern from the Justice Manual, and also that you could release that information without concern for things like the potential complications from the Supreme Court's immunity ruling, redactions necessitated by ongoing litigation, and so on and so forth. Like there is kind of a truth-telling mechanism embedded in the special counsel system, and it's the report.
Charles asks, how is it possible to pardon someone who has either not admitted or confessed to the crime or has not been convicted? And what does the team think about the appointments of Blanche and Bovee, and will they be faithful to being officers of the court or to the rule of law, or will they be faithful to the orange guy? So I'm curious for others who sat through the trials' sense of Blanche and Bovee, and also who watched them in Florida. On the first question, this is something people don't understand about a pardon. A pardon is not self-actualizing. It has to be pled to be valid. So if you're president, you can pardon, I can pardon Natalie for stealing eggs. And if she didn't steal any eggs and she's not charged with stealing eggs, then she just doesn't go into court and plead the pardon. If somebody ever approaches to her and says there was a giant egg theft on Wisconsin Avenue, the whole truck was taken. Uh, where were you the night of the egg theft? She can waive the pardon in their face. But the pardon exists is a document that alleviates for you the consequences of the criminal act. If you didn't commit it, it has no application to you. Who has thoughts on Emile Bovey and Todd Blanche? All right, I will just say on this one, there are sighs of relief all over the Justice Department about these two appointments. And Todd Blanche, he got a lot of guff during the trial for, being, I don't think it was his best effort. He's got a difficult client. He was a pretty well-respected Southern District prosecutor. Emile Bovey is a very, very fine lawyer. And I, first of all, have confidence that they will recuse themselves from matters that they worked on. They may infuriate their client by doing so, but I actually think we should assume they will live up to the ethical standards that they're required to. I have not seen any evidence that either of them has behaved unethically, by the way. Secondly, when you compare them to the quality of person that Trump is attempting to appoint to other Justice Department positions, like Pam Bondi or Matt Gaetz, these are in a different league. They're just wildly better. And they're people who actually know something about the department and its traditions. And so is it weird as hell? Yes. Am I against it as a matter of principle? Absolutely. Am I going to lift one finger to oppose Emile Bovey or absolutely not. And if you want to see what I think of Emile Bovey, look at what I wrote during the trial. This is an excellent, excellent lawyer. And by the way, Todd Blanche, I think, is a less excellent lawyer, but he's fine and he's reasonably well qualified, and that puts him at the top ranks of these nominees. And so I don't think it's right. I don't think it's appropriate. And in the triage list of things that I'm going to be anxious about, it's pretty low on the list. I'll be curious whether any of my co-panelists disagree with that.
No, I mean, as someone who has represented very unsympathetic clients, I certainly don't have any qualms about their decision to have represented him. I think that there are questions for me about the ethical obligations that they have continuing to trump as their former lawyers of him in his private capacity versus moving into these new roles where their client will absolutely positively not be Trump in his individual capacity. It will be the United States of America. And so to the extent, Ben, as you say, if they recuse themselves from things that are directly at issue, that may resolve some of the ethical quandary. If they don't, then I think it gets very complicated.
Then they should be disbarred. That would be an actual conflict of interest.
And we've seen the great bravery with which the bar associations all over the United States have been enforcing the ethical requirements of their attorneys. But, I think that we'll see. They very well may be very true to their ethical obligations as lawyers. They may take over this new role as very good actors, or we may have reason to be concerned. I don't think I'm as unconcerned as Ben is, but I am not also not inherently suspicious.
Quinta, Roger, Anna, did you guys have thoughts on this one?
I have to admit,
Whoops, you just muted yourself.
you're right that they're good lawyers, and so presumably it's good to have them than many of the alternatives at DOJ. But I was surprised by some of the language in these cases. For instance, the latest Trump motion. At some point, Matthew Colangelo left the DOJ and went to the DA's office, and they developed this theory out of nowhere that that's how Merrick Garland put his guy in, and got Bragg to just, do whatever Garland wanted. That's how Biden controlled the DA's office. Now, there is zero there. And how can you do that? Maybe that's zealous representation of the client. I'm not an expert. And then just this, throughout both federal trials, this Jack Smith was, quote, a Biden campaign surrogate. You put that in, is that really professional? And you have a speck of evidence. This whole theory that that the either federal case was politically inspired comes down to one New York Times article, April 2nd, 2022. And Katie Benner and a couple others wrote it. And they say basically that I can read it to you. As recently as last year, that means late 2021, Mr. Biden confided to his inner circle that he believed former President Donald Trump was a threat to democracy and should be prosecuted, according to two people. And while the president never communicated his frustrations directly to Mr. Garland, and they take that phrase out, he has said privately that he wanted Mr. Garland to act less like a ponderous judge and more like a prosecutor who is willing to take decisive action. So the theory is that Biden leaked that information to the Times so they would print it, and that would light a fire under Merrick Garland's butt. And that's the whole theory. We've been doing this for over a year, and that's the whole theory that is hammered, 30 times a motion, whatever the motion is about, that this is, I don't know. I'm not an ethics expert. I thought it was extreme.
Okay. I want to roll back my a little bit. I'm not disagreeing with Roger, actually. I think some of the language of those briefs, which I've also stumbled over a number of times, and I think a lot of that, I actually don't know what the line is between ethical making every argument. You're obliged to make every argument that might help your client. And there are at least some Supreme Court justices who might be sympathetic to that argument. So I don't know where the line is between that and just bullshitting to a court in a fashion that we would think is really inappropriate. And there have been times when I am have been troubled by some of the arguments. I'm not disagreeing with Roger at all. You put them next to Kash Patel, right, who is the nominee to run the FBI. You put them next to Matt Gaetz and Pam Bondi, and these guys look like exemplary members of the bar. And so it's really we're looking at the same coin, and it really just depends what side of it you're looking at, I think. All right, we're going to get through a couple more questions. Um, uh, Pete asks, I frequently hear that Trump's punishment doesn't fit the crime in all his cases. It seems obvious that Trump fought the government when he stole the secret documents, while Pence and Biden opened their doors, to cite just one contextualizing example. But how do Trump's indictments stack up in the history of law? To me, the prima facie case in Georgia, with its fake electors and phone recordings, is a real slam dunk of guilt, but it's not convincing to Trump voters, even intelligent ones, who still cite journalists for information and not just Fox News. All right, I'm just going to throw an idea out there, which is there is nothing to compare Trump to. And so how does it stack up in the history of law? I don't, we really haven't had that many cases where we've accused presidents of stealing a lot of classified information, or having a coup, or pressuring state secretaries. So there's nothing to compare it to. There's only two reference points that seem to me to be worth anything. One is the statutes in question. And here, I think the classified document statutes and the obstruction statutes are just crystal clear. Trump was just obviously guilty on the classified document stuff. It's a little bit less clear in the January 6th case, not because the fact pattern is better, but because the how you fit it into a statutory scheme is tricky, as we saw with the Fisher case and with some others. That said, I don't really doubt that if you tried that before a jury, he's going to get convicted. And then the third case, which is, we've talked at length about the New York case, so I'll leave that be for now. The Georgia case, look, they have this crazy broad RICO statute. I don't doubt that you can make out a case under that RICO statute, and that but for the whole immunity stuff, she did so in a fashion that I think if you tried before a jury, he would likely get convicted. So I look at the stuff and I say, and in New York, we know the answer. He was tried in front of a jury and he was convicted, and that conviction will be wiped out, but not because he didn't do it, not because he was innocent, not because the statutory theory was defective. So I think at the end of the day, there are at least 3 and maybe 4 pretty strong cases, and the evidence was overpowering in at least one of them and maybe more. We're never going to know more than that, but that's my supposition about it. Does anybody have stuff to add there? All right. Jeff asks, any guesses, Quinta, about how much detail Smith's declination reports will leave, how much he can reveal about his planned case and evidence?
I want to know what Anna's dog thinks.
Anna's dog is named Lucy, by the way.
I want Lucy's thoughts. In all seriousness, I don't know. The most recent special counsels that we've seen have been pretty detailed in the reports that they filed. So Mueller, Durham, Hur, they've been pretty expansive, sometimes to the point of mild absurdity, I think, in the case of the Hur report. I think it's really difficult to know what how Smith will think about the role, because there's not a huge amount of guidance. And to some extent, you could argue, that there's a additional layer of complication in releasing a lot of information that would have been released over the course of a criminal trial against someone who may now not be prosecuted, or may not be prosecuted until 2029, given that we know, in the Mueller report, the Mueller team noted that there was this complication of, the decision to release evidence against or information, indicating potential involvement in a crime against someone when they weren't being charged, which is, typically frowned upon for good reasons. So there are complications there. I think it's really hard to say. You could kind of argue it either way. And I think there's really no way to know until we see the report, if Garland decides to release it, which he may not.
Quinta, Lucy would like you to know that she agrees.
Lucy, you're a great American. We are going to leave it there. We got through most of the questions, not all. Apologies to the ones we didn't get to. We're never going to get to them because this is the last ever episode of Trump's Trials and Tribulations. So to everybody whose questions will forever go unanswered, my apologies. Natalie.
Don't forget about our auction, Ben. You need to announce our auction.
I need to announce our auction. Folks, we have an auction, and it is an auction of amazing stuff generated during Trump Trials and Tribulations. It's on our Give Butter page. We're going to put a link to it in the show notes. And it includes the doodles of Anna Bauer in court. It includes photographs by Tyler McBrien. It includes courtroom sketches by Quinta Jurecic, and they are all up for auction to support Lawfare. So, bid, you can get an original piece of memorabilia from Trump Trials and Tribulations. And who wouldn't want that? For the last time from the Mar-a-Lago bathroom studio, it's Ben Wittes. From the Scott studio, it's Roger Parloff. From the endless screaming pillow studio, it's Quinta Jurecic. From the Martha Stewart kitchen studio, Tyler McBrien. From the Burn Your Records in a Fireplace, it's Anna Bauer and Lucy the dog. And from the Boring Office studio, Natalie Orpett. We will see you